Maragos. I'm the County Comptroller. Ladies and gentlemen, the Comptroller's Office reviewed the proposed agreement with Veolia to operate Long Island Bus. We evaluated the agreement from a number of aspects, and we compared the operating arrangement under the Veolia agreement with the MTA service reduction plan that was submitted by the MTA. The evaluation aspects that we used were service levels, financial impact, risk liabilities, local control, and other intangibles. Some of the metrics that we have found is that the daily impact on riders on a route basis will affect approximately, Veolia arrangement will affect approximately 13,000 daily commuters versus the MTA. The MTA would have affected 16,800 daily commuters. Veolia only affects 3,800 commuters. The daily percentage rider impact that those numbers represent, MTA would have reduced service by 16%. Veolia will only reduce service by 4%. The daily vehicles hours impact, if we look at it from an actual total hours of vehicles on the road serving the public, we found that the MTA would have been providing a total of 926,000 vehicle hours. Veolia will provide 50,000 more hours of vehicles on the road of 980,000. Able ride, the MTA was proposing a 50% reduction, while in the next 2 years, Veolia will not impact able ride the paratransit at all. The Metro card is an issue that is open, and we were happy to hear that Veolia is close to an agreement with the MTA to provide a very important service, the Metro card transfer service, which affects 33,000 daily riders. From a county cost impact, the MTA plan, assuming there was no additional subsidy, would have required the county to pay an additional $9.1 million annually. The Veolia plan will require the county to pay $2.5 million, approximately $7 million per year less. We also look at the risk liability from a 13C labor obligation. As the MTA would have had no impact on additional liability to the county. Under Veolia, we made certain assumptions that, as I heard in the prior presentations, may not come to fruition. We had assumed, because of the reduced route and vehicle hours proposed by Veolia, they would require less drivers, less mechanics, and our estimate was that they would require about 168 less union employees. As a result, we calculated a potential maximum risk liability to the county of $23 million. We are happy to hear that most, if not all, of the employees will be hired, and if they are indeed hired, then this liability would not materialize. As far as we see some risk with regards to the state and federal grants. Those are generally tied to service levels and number of riders on the buses, and we think there should be very little or minimal impact to potential reductions in state and federal grants. Some of the intangibles that we found in the contract that we thought were beneficial to the county were greater local control, as was indicated. All the members of the Transit Committee will be county residents. The county subsidy to the ongoing operation of Long Island Bus is guaranteed at $2.5 million over the next few years, again substantially less than what the MTA would have been. And then we have the additional benefit of potential newer technology and improved service through this better technology that we deem Veolia will be offering. So in conclusion, our assessment is that the Veolia agreement can provide a higher level of service at lower cost with greater lower control. Thank you.
Thank you, Mr. Maragos. Anybody have any questions for Mr. Maragos?
Yes, I have a question.
Who said that? Legislator Link.
Mr. Maragos, you commented on the 13C provisions with respect to this proposed deal with Veolia. Have you had an opportunity to review any legal opinions with respect to 13C?
We consulted various attorneys. We also plus some outside sources, and again, it's there is a debate as to the level of liability, but our summary was that the extent of the liability would be limited to the extent that the employees are harmed or their compensation is reduced over the next 6 years. So on the basis of that assumption of damage to or harm to employees, we estimated that the maximum impact would be in the range of maximum $23 million.
And you use the term harm to employees. How do you define harm to employees?
Well, either reduced wages or employees not hired and not being able to find gainful employment.
Okay. Have you had an opportunity to review an opinion that was provided to us today by the firm of Comptroller, O'Hara and Mills LLP, who purport to be the attorneys for the Transport Workers Union Local 252?
No, I have not seen that.
Okay. I'm going to ask, does the clerk have an additional copy that can be provided to the Controller's office?
I don't. If you want to give me that, I'll make photocopies distributed to the legislature as well as.
Okay.
No, do it now. Legislature have it.
I'm gonna, I know legislators have it, I thought it was distributed by the clerk.
I don't have a copy, I'm sorry.
Alright, I'm gonna give you a copy, if you can have it distributed to the Controller's office. I'd very much like to get your opinion on this, as soon as possible. I understand, from newspaper accounts that we're not going to be voting here today, and that in fact the vote will more likely to take place on December 19th. I'm gonna ask for the record that you provide a legal opinion, or excuse me, your opinion as Controller, based upon this opinion that's been provided to us here today, as to what, if any, liabilities you believe the county would have as a result of this.
I'll be happy to do that. Would by the end of the week be adequate?
That'd be wonderful. I appreciate it. Thank you very much.
Yeah. I'm talking about it.
You want a legal opinion?
I want an opinion from the Controller. He just spent the last 20 minutes giving us his opinion of this deal. Seems to me this is a pertinent provision of this.
That's fine. When you mention legal, I'll be the county attorney.
I refine that to indicate an opinion from the Controller.
He's asking for a response to a opinion from an attorney. How could we have the Controller respond to an attorney's letter? Wouldn't it be reasonable to have the county attorney to respond to a legal opinion?
Well, he's not the only one I'm going to be asking for an opinion from. The fact of the matter is the Controller has used not only legal opinions that have been provided to him by outside sources, and I assume by the county attorney, to come up with his opinion on this. It seems to me that this needs to be part of that panoply of opinions.
You can ask him whether it changes his opinion or his report if he looks at that, but to have him specifically respond to that report is inappropriate It's beyond his capabilities, he's not an attorney, and it's impossible.
And I don't believe that's been the case at all. In fact, he's taken a number of opinions into account when he gave his opinion here today.
As I said, you can take into account. You can take it into account, if it varies his report, he can report on that. He cannot, however, comment on the legal opinions rendered in that report.
And Mr.
It's simply
Nicola, I
the
have
attorney's office that has the capability to do that as an attorney.
And I have no doubt that if Mr. Maragos' opinion doesn't change one iota as a result of this opinion, he will provide that information to us.
Thank you. Wait 2 hours
I think Mr.
Again, I want to
Maragos-
stress, we will
I
not
think
be
Mr.
providing a legal
Maragos-
opinion, but rather a financial opinion, a financial impact.
That's exactly what I was going to say, exactly right. And I think Mr. Maragos is very capable and able to render you that opinion. However, I think it is unfair of you to expect him to tell you who he talked to or what he thought when he was writing his own opinion. That's personal, private information. He doesn't have to share that with you.
Mr. Chairman, to the extent that Mr. Maragos is giving a considered opinion on this deal, it seems to me that it's only pertinent that the public information that's been provided to him so far be part of that opinion. I don't see where probing what opinions he's basing this on and what interpretations he's basing this on is somehow inappropriate. This is a public document that Mr. Maragos is presenting here today.
Which is a public document that states his opinion. What went into forming his opinion is his business. It's his opinion. You have it. You can ask him to comment on that or on other documents from a financial point of view, but you can't crawl inside his head.
I think you're parsing things here, Mr. Chairman. To the extent that Mr. Maragos is weighing in with a significant opinion as to whether or not this is a deal worth pursuing, it seems to me that there is nothing inappropriate about probing the basis by which he forms that opinion.
Wonderful. Legislative is on.
Mr. Maragos, in regard to revenues coming into the Veolia budget, is there the possibility that grants will still be forthcoming to Veolia as it was to the MTA? In other words, is there stability insofar as the grants that would be received to this new agency?
The only reason that we see, first of all, our understanding with regard to the grants, those tend to fluctuate depending on both what the federal and the state governments elect to allocate in terms of total grants to all local communities. There is a secondary effect, though, in determining the level, and that is the commuter riders, the total daily annual riders. So to the extent that those are being reduced, as I indicated in the case of about 4,000 daily on the Veolia side, but 16,000 on the MTA, if there would be any impact, there may be some impact, we would hope that it would be lesser under Veolia than under the MTA potentially.
Well, it's understandable that under these present circumstances, given the economy with the federal government and the state, money may not be so forthcoming, but they still would be eligible to receive grants if the funding is available.
That's correct.
Okay, thank you, Mr. Maragos.
I'm sorry, Mr. Schmidt.
Wait a minute, Legislator Dannenberg. Well, you had your hand up first.
Okay. All right. Good afternoon, Mr. Maragos.
Good afternoon.
First question, this is Comptroller's limited review of license agreement between the county and Veolia, correct?
Yes, sir.
What do you mean by limited review? I don't know why you need Mr. Maroney to help you with what you mean by limited review, but seriously, why is it limited?
Well, the Comptroller's Office has certain protocols with regards to the documents that it issues. And if it's not a rigorous, formal audit, then the level of document below that is called the limited review. And we've issued similar limited reviews in previous testimonies to this legislature. Actually, all our documents and reports that we've been submitting to the legislature have been limited reviews, whether it be of a budget
Feeling kind
nature
of bad
or...
that we only get limited reviews, but,
She would.
okay,
We'll
so.
give you a lollipop later, come on, let's.
You know, that's, come on, Peter. Unbelievable. One of the recommendations that you made is that fare adjustments should be changed from quarterly to annually. The potential of quarterly adjustments would harm public confidence. So what you're saying is that as you read it right now, fares could be adjusted every quarter as opposed to just once a year.
Theoretically, from a contractual point of view, it allows for that. We don't think that's going to happen, but we just want
So one of your recommendations is that the contract, which theoretically right now, or the contract right now provides that fares could be changed quarterly. In your recommendation, we should make sure that fares contractually can only be changed annually, correct?
That's what we recommend.
Okay, now the fixed fee should have some relationship to the variable fee. The county should not, and I'm just looking at your conclusions here. The county should not be put into a situation where service is substantially cut while the fixed fee represents a significantly higher percentage of the total payment to Veolia. What are you trying to say? So that we can have reduced revenue, but the fixed fee to Veolia would be the same?
Well, we're saying the ratio, normally in any operation, you have the overhead or administrative cost should be a certain percentage of the operation varying from industry to industry. So in a case, it may be 25 or 30%. And when those numbers start getting much higher than that, then you basically can have an inefficient operation. So it's a guideline, a management precaution, if you will, for our metrics to be monitored and somehow have some bounds on it.
So what is that ratio right now? What's the fixed fee you said represents a significantly higher percentage?
Well, it's about 27% now in a contract. So we would like to see that remain below 30% as a guideline.
Okay. And if we reduce that percentage, then the total payment to Veolia versus the variable fee that the county might get could be less. That would be better for the county.
Well,
I'm trying to understand this in layman's terms. What do you recommend?
Well, remember the county is only contributing $2.5 million towards the operation of the bus versus 9.1 that they were previously paying the MPA, or they're currently paying the MPA.
Right.
And they will continue to, our reading of the contract, 2.5 million for the next few years, the term of the contract. So that's a substantial savings to the contract. The rest of the revenues that were accrued from the operation or from the grants will go towards the operation.
So if the county remains under this contract paying 2.5, which is what it says, right, which is significantly less than the 9.1, if the rates that Veolia charges can be changed after the first quarter, and they charge more per hour service, but the county contribution remains 2.5, that difference could only come either from state and federal grants, which look like they're going down because under, that's one of the concerns you raised, that state and federal grants would go down. So the only difference could be fares, correct?
Oh, it could be fares, it could be advertising revenue, or it could be
reduced service.
Or it could be a reduced service, yes.
So unless the ad revenue is going through the roof, when there's a rate increase from Veolia,
Right.
if we're just paying 2.5, it's coming from the fare goers, or we get reduced services.
The same thing would have happened with the MPA, and probably at a much higher rate. Because what we've done.
I'm not looking at the MTA deal right now, I'm looking at this.
Our study attempted to compare both the financial aspects and the level of service provided by both the MTA and Veolia, and to make a determination as to whether it was in the best interest of the county financially and from a service level under the Veolia agreement. And I guess our conclusion is that it is. There are some risks, some aspects that we recommend be looked at and maybe somewhat refined.
Those risks with the 13C liability, which could be up to 22.8, you put that in here. The other risk is that potential service cuts could impact the federal and state aid. We're gonna end up getting less federal and state aid, won't we?
Yes or no is the question.
The answer is, when compared to the MTA, we're gonna be getting more.
Yes or no is the answer.
We're gonna get more federal and state aid.
Well, the MTA would have reduced ridership by 16,800
You know what?
per day.
Right now, what did we get in 2011 from federal and state aid?
Right. But
Not right, I'm asking, what did we get from?
We got about 53 million.
And you don't see us getting less under this contract in federal and state aid than the 53 million we got this year?
No, the appropriate way to look at it is what we
We're not gonna get less than 53?
The appropriate way to look at it is what we would have gotten. Well, you gotta compare apples to apples. You want an
We
answer?
got 53 million this year, I wanna know what we're getting under this contract, what are we gonna get in state and federal
Well,
aid?
if Veolia was under the ridership, this year, Veolia would have provided 12,000 daily riderships a day more. And therefore, we would have been eligible to get more grants, not less.
Are we gonna get more or less in this contract than 53 million?
That's not
I'm
the way to
asking
look
about
at
this
it.
contract. Are we gonna get more or less than 53 million?
First of all, we're not gonna know what we're gonna get.
Are you really not gonna answer my question?
Your question cannot be answered in a reasonable and logical way. Because, well,
The bottom one thing was clear, Veolia is, under this contract, Veolia is gonna charge a rate. What you recommend should at least be established annually as opposed to quarterly. And I agree, it should be established annually, if not more than 1 year, at least annually instead of quarterly. But when they charge the county a rate, the county can only pay it, come up with that money in 3 ways. Federal and state funds, or other funds, maybe advertisement, county contribution, which we're keeping at 2.5, you said, under this contract, and fares. So unless I can see some assurance that federal and state funding isn't gonna be less under here, at some point, if the fare goes up, if the rate that we charge from Veolia goes up, the only way to make up that difference is gonna end up being fares. And that's really what bothers me. Unless we allow less routes, because then of course the rate will be less. Am I missing something?
Yes, you are.
What am I missing?
Well, first of all, you're asking different questions.
Don't let him insult your
On the first question, what I'm saying, because the ridership would have been less impacted under Veolia, whatever the grants are going to be next year, they would be greater under the Veolia agreement that they would have been under the MPA. Okay? So we
Even
get
though there's
this.
a profit, reduction?
What I said is that under the Veolia, because of the lesser ridership impact, and given the formulas, the county will be receiving higher grants than under the MPA.
If the MTA reduced services 50%.
If the MPA would reduce services to the extent that they have proposed. Okay? So
Okay.
that's the
I mean,
best
we're
way to
assuming
answer
that
the
proposal-
The separate question is, if there's a shortfall in revenues, whether it be in fares, advertising, or grants, then the difference will have to be made up either through fare increases or other additional funding from the county, or possible service.
Okay, thank you, Mr. Danielberg. Legislator Troiano.
Good afternoon. You know, we just got the report a little while ago, so a lot of us are scurrying through trying to read it now. And I may not incorporate everything that you've embedded in this, but I want to ask a couple of questions about, again, the 13C obligation.
Sure.
And I'm going to ask for your financial business approach responses to this. You cite as a potential liability, and you cited at $22.8 million for 13C liability.
Correct.
And you say that those risks might be mitigated through negotiation with the TWU or through arbitration.
Correct.
But we don't know that that's going to happen, in fact, do we?
No, we don't.
So, as a business person, I would ask you, what happens to that $22 million liability if, in fact, it can't be mitigated?
Then presumably the county will have to, it's a county liability in our estimation, or there will have to be adjustments to the bus budget.
So as a person with some responsibility for the county state of finances, or at least commenting on that, you've issued many releases about the state of the county surplus or deficit from time to time. How comfortable do you feel as controller with the county taking on this additional $22 million risk and this legislature voting on this contract before we know whether or not a negotiation will be reached with the TWU?
Well, I saw my responsibility to highlight the risk and to put a metric on it, or try to estimate for your benefit the size of the potential liability.
Yeah, I'm asking you to keep your controller's hat on.
Right.
And if you know that the county may have an unbudgeted, as far as I know, unbudgeted $22.8 million that it may have to incur, what are your thoughts about that? As a budgeter.
Right. My thought would be that under the MPA proposed plan for next year, the county would have had to pay approximately $56 million more. So that liability, estimated at $23 million, it would be $13 million less.
But that's not the contract we're being.
What the
That's not the
county
contract
would
we're
have to
being
pay.
asked to approve right now. We're being asked to approve the contract with Veolia, which contains a $23 million potential hole in the county's budget.
No, but as controller, I have to look at the overall impact to county finances.
Exactly, that's what I'm asking you to do.
Different
The
scenarios.
overall impact to county's finances.
Hold on a second. Is the county attorney now? Mr. Chiampoli, is discussion of 13C appropriate in public, or does that have to be an executive session?
Legislator Schmidt, there is a pending litigation with the Transport Workers Union. I believe it has been the practice of the legislature to hold discussions that relate to such litigations in executive session.
And thank you for that clarification, but I have not asked I've not asked about your opinion about 13C. What I've asked is your opinion about the impact of that on the budget. No, not at all. Look, okay, Mr. Maragos, let's say there's a hypothetical liability. Nothing to do with 13C. Just a hypothetical liability for $22 million in the county's budget. As the controller for Nassau County, how do you feel about entering the year with that kind of risk outstanding?
Let me answer that. As we commented in the 2012 budget, that there are substantially greater liabilities. A number of items have not risk, they're risk liabilities in terms of, sales tax revenues, in terms of other operating expenses that have not been well defined. So there are risk items, and we're outlining this in the context of the bus agreement as another risk item that has a potential cost liability to it.
Okay. And we're kind of throwing that 22.8 as though that's the right number, and we don't know that, and you don't know that.
No, and there's some, a discussion as to how we arrived at that number. You may disagree with it, and we certainly are open to further discussion on estimating that liability. And if our assumptions are incorrect, then certainly we've showed what the format is that we use, and we'll be happy to revise that.
And you've made, I think, some reasonable assumptions as far as I've read this far.
Yes.
And so you're assuming there are 2 drivers for all the routes that get eliminated based on your best projections.
That's correct, but what I heard before in the prior presentation, that is the intent of Veolia to hire all, if not most, of the TWU employees, in which case that liability would be probably significantly reduced, if not eliminated.
Or it could be a lot higher, because it could get, as far as your calculation, it could be as high as 89.4 million.
So not the important
At what point, as a controller, does the risk become too large for you to be uncomfortable with?
If I may, Legislator Schmidt, I'd ask the members of the legislature and the comptroller to frame their questions within the existing facts. The existing facts are that right now there is no 13C liability. We have attempted to create a situation where there will be no 13C liability. And as the comptroller has said, he's working on several assumptions which may or may not come to pass, may or may not be true. And we can go into a legal analysis of whether or not we ever cross the threshold of incurring 13C liability. We can go into analysis of the contract provisions which protect the county in the event there's 13C liability. Okay, but again, particularly because there's outstanding litigation, those matters are best discussed with the legislature, and you certainly have a right to know, but it should be done in executive session so that we protect the county from incurring the liability.
So let me reframe my question. Let's again put in the realm of the hypothetical. And is there a level at which, for any kind of liability, is there a level at which you as controller feel uncomfortable about this legislature approving a contract with that level of risk outstanding?
There is no risk.
Well, it was his report that I'm reading from, Mr. Schmidt, that says there's a risk of 22.8 million. It's his report. Don't tell me there's no risk. It's his report.
The county attorney just testified to the fact that there is no 13C.
And I said in response, this is hypothetical, not related to 13C, just in general. At what level do you as controller get uncomfortable if the risk is too much, no matter what the liability might relate to?
There is no level, because it depends on the context. In the case of the budget that we went through, 300 million was a significant level. 100 million would not have been a significant level of risk. Would have been a minor risk, actually. In this context, until we see the final agreement, until we know what the outcome is going to be with the labor negotiations, we will not be able to estimate.
And that's my concern, Mr. Controller, is that you so easily minimize this potential liability, saying that it might get resolved in contract negotiations. And we do not know that yet. And so the
I
legislature is
think
being...
we differ. I have not minimized it. If anything, we have highlighted it in the report.
Well, I'm sorry, you said reliability may be significantly reduced or totally eliminated depending on negotiations with the union. And that's my concern, is that we don't know that. And so therefore, it seems to me imprudent for this legislature to go forward and vote to affirm a contract when we don't yet know the outcome of negotiations that are going to happen next week.
I made the additional statement that in our judgment, the additional cost that the county would have been paying to the MTA, which would have been $36 million, far exceeds any potential liability that we estimate.
Okay, we've gone back, I'm not going to pursue it anymore. I just have one last question for you, okay? And that is, and this may exceed your knowledge as controller, and Mr. Nichols already defended you having to respond to legal questions. But do you know if the union reaches an agreement with Veolia and the county that limits the 13C liability, maybe down to 0, and then later...
I'm going to shut down 13C.
Can I finish the question?
No, nothing has to do with 13C, it's out of order.
I'm sorry, because of the concern about the lawsuit? Okay,
Absolutely.
fair enough. Thank you. I'll ask the question in executive session.
Would you like to go to executive session?
No.
No, not now.
It's a public talk.
John?
There's a lot of conversation and extreme concern about fare increases. I think that's on both sides of the aisle. Okay? My understanding is if there's going to be a fare increase, it has to go to a committee. That committee of 5 people. Is that your understanding as well?
Yes.
All right, thank you.
Legislator Jacobs.
Yes, Mr. Maragos, I'm sure you know this is going back, as far as hearings go, almost 2 years now. With the concern originally of able ride cut in certain areas and never restored, and the concern of losing bus service. So I believe that there isn't anybody sitting up here that doesn't know the importance of keeping our bus service running. And the thing, I want to make one statement, and just correct me if I'm wrong. I'm not a lawyer, so that's good, because I'm not going to ask you.
Neither am I.
But I'm going to ask you a layman's question. It seems to me, when I read over the contract, that although people would like to make Veolia the bad, so to speak, bad guy here, in truth, there really is none. The county has the real hammer in this as whether to lower it, raise it, or whatever, not actually Veolia.
That's correct.
Okay. Took me about 3 minutes to realize that as we were discussing it the other day, and of course reading it over. I have one simple question for you. Is your suggestion that this contract with Veolia be approved for Nassau County? Just a yes or no?
Yes, because it's a better, higher level of service at a lower cost compared to the alternative with the MTA.
All right, I appreciate that, because I think what we want to know, when people get up to speak, who are like you as the controller, or the county attorney, or anyone getting up from the public, we have to know where you stand. And you are comfortable recommending the contract with Veolia. That's what I want to know.
Yes, I am, because the alternative would have been worse at a higher cost.
Okay,
more impact, negative impact to the riders of Nassau County.
And knowing you, I would assume, I know it's bad to assume, that you share the concerns to the riders that we will do.
Yes, I do very much.
I hope not. I hope not. We all are concerned with cost, there's no question. But we are concerned with the human element in this. And it's very real, and it's very touching.
That's correct, and as we indicated in our analysis, that 13,000 daily riders are going basically have service that they would have had, that they would not have had under the MTA proposal.
Okay, thank you very, very much.
Thank you, Mr. Jacob. Okay, moving on to public comment. What was that? I'm sorry, Legislator Nicolella.
I just wanted to, and again, this is not going to touch on the legal aspects of 13C, but there was at length, you were questioned about what about the impact of the county's budget if there's an award. I'm looking at the Office of Legislative Budget Review's report. A 13C claim or award would constitute a major event in which would then Veolia would have the opportunity to make major changes. Is that correct?
That's correct.
All right. So that basically is fair increase in service costs, et cetera.
Upon approval by the transit committee.
Upon approval, right. Now, if that's not approved, my reading of this is that Veolia is required to indemnify and hold the county harmless. So if the major changes aren't approved, it's not a hit to the county budget. They're required to indemnify us. It's in the contract, it's in here in the Office of Legislative Budget Review. So, is that your understanding?
I think now, I'm gonna say that that's a legal opinion, but I don't want to comment on it.
Okay. I want to just make part of the record a letter I received from Edward Robb of the 21st Assembly District. Mr. Edward Robb, this is part of the record. You have it.